homegrown public interest law firm that is committed to advancing racial, economic, and social justice throughout Mississippi. The scope of our work is far reaching. We have lawyers and advocates dedicated to consumer protection, fair housing, educational opportunities, healthcare, and public benefits, disaster recovery. We also have our George Riley Impact Litigation Initiative, which focuses on voting and election rights, reproduction rights, criminal justice reform, and discrimination. Another area of MCJ's focus is immigration, and that is a topic we're here to discuss today with MCJ's immigration team. Today, you will hear how the U.S. immigration courts are failing immigrants whose only crime is a desire for a better life. This happens for a number of reasons, some active and some passive, some systemic and some subjective. We'll touch on many topics today, from asylum hearings and public charge to the immigration experience today in detainment. But before we move in today's conversation on immigration, I want to invite you to join MCJ for our 2020 Virtual Champions of Justice Great Mississippi Road Trip, scheduled for October 22nd at 4:30 Central Time, another Facebook Live event. You can find out more about that at mscenterforjustice.org/champions. So to introduce MCJ's immigration team, here's Riley Morris, MCJ's General Counsel and Advocacy Director of Immigration and our George Riley Impact Litigation Initiative. Riley will also serve as the conversation's moderator today. Riley?
Thanks, Vangela, and thanks all to you for showing up for this briefing. We're really grateful for you taking the time to remain interested in this issue. It's 1 year since hundreds of immigrants and their families had their lives torn apart by ICE raids at poultry processing plants in central Mississippi. And today they face deepening uncertainty and poverty. Some remain in detention, and others who are released find little to no work. They face risks of exposure and extended delays of their cases. Meanwhile, a year later, not a single corporation or top-level executive faces a single charge. Only a few mid-level managers were charged the day before the 1 year anniversary. Now, these and other meatpacking facilities in America remain open under federal emergency orders, despite being COVID hotspots, due to long working hours and crowded conditions. And Mississippi has not reported meat processing plant infection data, unlike 23 other states. In Mississippi, immigrants represent only 2% of the population, and they also represent no danger and account for no rise in local crime, according to local law enforcement. Mississippi is an immigration law desert with only a handful of public interest lawyers representing persons in the system and no courts in the state to handle removal proceedings. At present, about 225 detainees have been removed already due to prior immigration orders or other causes. 50 remain detained. Another 105 have been released on cash bonds or humanitarian release, joining the approximately 300 released on the days of the raid. Today, we're going to talk with MCJ's immigration law team, Director Amelia McGowan, Staff Attorney Max Myers, and Community Organizer and Outreach Specialist Nancy Sanchez Vasquez. Amelia, you're a law professor and a practitioner and have been deep in this work for years. How would you lay out the case that justice in the United States immigration system is just an illusion?
Riley, that's a great question. And I'd actually like to start with a clip from one of our clients to sort of get the conversation started. So this language that you heard is Chu, which is one of the 23 indigenous languages of Guatemala. And that's a country with one of the highest indigenous populations in the Americas, at around roughly 50%, and some estimates are as high as 60%. This is a language that existed long before European colonization of the Americas. And while the modern version of Chu has some borrowed words from Spanish, it is its own language. And in many ways, it's as different from Spanish as English is from, say, Mandarin Chinese. This happens to be the native and best language of many Mississippians arrested in last year's ICE raids that you mentioned. And under the law, they should be able to participate in their own deportation proceedings in their best language. And that's because in the United States, we have fundamental guarantees, such as the guarantee that everyone will have a fundamentally fair hearing, a guarantee in which people will understand the charges against them. They'll have a right to be heard and present evidence in their own defense, and before a judge who decides the case impartially without bias. In fact, as we all know, our justice system is held up as an example to the world of how people should be treated in court. And that's not just applied to US citizens, but for anybody seeking refuge here. Certainly was not the case for one of our clients, Ava, a Chu woman who speaks this language and was seized in the August 7th ICE raids. When she faced her deportation proceedings after her arrest, the court knew at the outset that she would require a Chu interpreter, but they set up hearings twice in which no such interpreter was available. The judge even suggested that Ava waive the right to interpretation in her best language just to get through her case more quickly. And Ava refused, as was her right, but was held for months longer than necessary. After 7 months in detention, at the final hearing to determine Ava's fate in the United States, she was forced to accept the Spanish interpretation of her own deportation proceedings. And she lost her case, unfortunately. So after she lived in Mississippi for 8 years with her family, she was sent back to Guatemala, which is a country that she feared. And other detainees like Ava in immigration detention are under severe pressure to avoid further imprisonment and risk of exposure to COVID-19 nowadays, and submit to hearings in English or Spanish, which may be languages that they don't understand or speak fluently. And their right as humans to tell their story and to defend themselves in a US court depends on interpretation in their best language. And she's just one example. Ava's one example. I also want to share an excerpt from a removal proceeding in one rural immigration detention center. Unlike Ava, this immigrant defending himself had no lawyer. He said to the judge, quote, "Please, just have mercy on me. I mean, it's been 1 year now, and I've seen whatever I'm going to rise my seasonal crucifixion. I thought that season should end today. It should be the season of my resurrection. I'm really tired. I sometimes feel like harming myself. I'm so tired. I'm so worn out. I want to," and the judge interrupted and said, "Well, sir, if you're that tired and worn out, you could have written a letter to the court at any time requesting that you be removed from the United States." To understand and meaningfully participate in a case, the immigrant must be competent to understand the proceedings against them. This client had untreated severe schizophrenia. He called the judge mom. He had visions during his hearing, and he expressed suicidal thoughts. And this case only moved forward because a friend at the detention center who was detained with him filed a notice of appeal, helped him file one, and the case was referred to as the Pro Bono Appellate Project. We won the appeal on the basis that the judge should have provided a competency hearing, and thankfully he ultimately won his case on remand. But this kind of callousness occurs when judges believe that nobody's watching them to hold them accountable. And that's what we as lawyers have to do. We have to hold the system to its promises. And just as another example, a client had tested positive for COVID-19 while he was detained. And he was so sick that officers had to drag him into his video asylum hearing. He was in Louisiana while the judge appeared via video from New York. It was kind of like a Skype Zoom hearing. And in the midst of a 2-hour-long hearing, granted he had COVID, I'm very sick, the judge said, "I was just advised by the officer at the facility that the respondent is going to be unable to speak because of his physical condition. I note that we have confirmed that he is able to hear what is occurring, but I'm certainly not going to require him to speak and be short-winded and unable to do so." This person literally lacked the lung capacity to testify in his own defense, but the judge moved forward. Only after a 2-hour hearing did the judge relent and agree to a continuance. 15 minutes later, detention officers rushed him to the hospital where he was admitted. It doesn't end there. When the client later sought to present his defense of persecution at his new hearing, the judge shut it down. His attorney asked, can you just describe how the Chumai are treated in your town? And the judge says, counsel, I'm looking for his personal experience. And the reason I say that is I can look at country conditions and whatever arguments you want to. My intention is to render a decision today, so marshal your proof. The trial counsel said, okay, Your Honor, just for the record, his claim is based on well-founded fear of future persecution. So I was trying to establish the fear in Guatemala based on that ground. The pressure to render a decision and the impulse to cut off a presentation in a person's defense comes from the Department of Justice's case completion quotas, which require immigration judges to complete 700 cases a year or face negative performance reviews. This has resulted in what many advocates call assembly line justice, and what one immigration judge referred to as hearing death penalty cases in a traffic court setting. It's the same daunting system that faced another one of our clients, a Guatemalan asylum seeker who sought protection in the United States after years of physical, sexual, and psychological abuse at the hands of her husband. At her immigration court hearing, she testified for nearly 4 hours in great detail about the abuse that she suffered. The years of beatings and rapes, and a harrowing account of the day her husband chased her and her children with a knife. Her testimony left no question about what would happen to her if she were forced to return to Guatemala. You would think that her case would be an easy asylum case to decide. It should have been, because the law at the time explicitly protected asylum seekers who were fleeing abusive marriages. But that isn't what happened. The judge refused to issue a decision that day and instead deliberated for 4 months until the Attorney General single-handedly overturned the Board of Immigration Appeals case that offered our client protection. The immigration judge then immediately issued a decision denying our client asylum. That actually brings us to another systemic flaw in the integrity of immigration court proceedings, and that's bias. Even though due process requires an impartial judge, that is often not the case in immigration court. As employees of the Department of Justice, immigration judges are under tremendous pressure to rule not in the interest of impartiality and justice, but rather in accord with the policies and mandates of their supervisor, who's the Attorney General. And these mandates have been increasingly hostile toward asylum seekers. While asylum seekers have suffered family separations at the border, the attack on asylum seekers in our immigration courts has been quieter, but just as deadly. And without these meaningful challenges to their decisions, area immigration courts have astronomical asylum denial rates. And that's especially for detained immigrants who are less likely to find representation. Nearby Gina Immigration Court in Louisiana, for example, has a 94% all-time asylum denial rate. And some area judges have an asylum denial rate as high as 98% or even 100% in the case of one retired immigration judge.
So Amelia, in the midst of all of these injustices you're describing, how is MCJ fighting back?
So, after all these, terrible scenarios, I actually want to end on a hopeful note because we have seen change. In the asylum hearing of one of our clients who's a Nigerian Christian pastor, for example, immigration judge in that case had a 98% asylum denial rate and told our client that even though Boko Haram beat, kidnapped, and threatened him and harmed his family, that the terrorist group would no longer be a threat to him because, quote, they saved all those girls. And that's obviously incorrect, first of all, but we fought back. Unfortunately, we lost to the Board of Immigration Appeals, but we appealed to the circuit court, the federal circuit court, who vacated our client's removal order. The court in that case strongly rebuked the immigration judge and the board for what they said, quote, they selectively considered our client's evidence and, quote, ignoring evidence that corroborated his claims. The court held that, quote, no reasonable fact finder could reach the conclusion that he suffered no past persecution, and that, quote, to find otherwise under these circumstances would essentially mean that nothing short of actually being killed would satisfy this standard. And so after a 6-year fight, justice finally prevailed. I just want to highlight here that the Mississippi Center for Justice Immigration Campaign is one of the very few nonprofit immigration programs in the country, and the only one in Mississippi that has a focus on immigration appellate representation. And as this client's case demonstrates, these appeals allow us to attack these affronts to due process head on and really gives us a hope for positive change.
Well, Amelia, thank you for that sobering and yet still hopeful account of things. Let's take a moment to turn to a different form of injustice that immigrants in Mississippi face, to our community organizer and outreach leader, Nancy Vasquez. Could you please talk, Nancy, about when we talk about the public charge rule together, you explained that this rule leaves the people you work with no good choice. They're stuck in trouble whichever way they turn. Can you explain a little more about that? How does this impact immigrant Mississippians?
Yes, Rauli. Outside of the immigration court, families of workers who were arrested in the ICE race facing a cruel dilemma due to another injustice of immigration policy. My job directly involves with being in contact with the families, either by phone or in person, and their stories, they heartbroken. One of the phone calls that I've been received is Mrs. Amalia. She is a mom speaker. She is a single mother and have 3 US citizen children. And she has been arrested in the ICE race last year, along with her sister-in-law, who has 4 US children. When I was talking with Miss Amalia, she was crying and telling me how her children, they've been suffering due to this injustice that they have for public churches rulers. The kids, they've been suffering for hunger and for other needs that they didn't have. And now that her sister-in-law, she is being deported, she has to be caring for her 2 other kids that she is being behind here. The story is not only that, the other 2 children who went back to Guatemala with the mother, they've been hunger and they've been suffering for not being in another place where it's home for them. What public churches does is pushing people who are eligible for public assistance for seeking it. The punishment is privileges those who do so from pushing against them. This policy goes from 1980s, when the US citizen demand poor immigrants to be undescribable, and unfortunately, that is the situation. I'm going to let Emilia tell us a little bit more about this issue, how the public churches does and how they affected the families.
Sure, Nancy, thank you for sharing that story. So just to give you some background information on what the public charge does, it punishes people who are eligible for public assistance from seeking it. The punishment is to prevent people who do so from gaining permanent residence in many cases. This policy actually goes back to the 1880s, when the US deemed poor immigrants to be, quote, undesirable and unworthy of entry. And since the 1990s, courts and prior administrations have actually limited the application of public charge to a very small percent of people. However, recently, as you may have heard in the news, the Trump administration reversed direction and extended it to parts of the social safety net that were previously excluded from consideration, such as food stamps, housing assistance, Medicaid, and others. And even though this rule doesn't apply to everybody, it has a broad chilling effect, especially on raids-impacted families. The nearly 700 people who were arrested were in many cases the only economic support for their families. Of the people who have been released, most have ankle bracelets and can't leave because to work. And because of the new public charge rule, they're fearful of applying for basic assistance, like SNAP and EBT, for example, for their US citizen children, because they're afraid that doing so will worsen their chances for an immigration status in the future. And this rule pushes immigrant Mississippians into greater risk of poverty, hunger, and illness, as the situation that Nancy described indicates.
Nancy, can you tell us a little more about the family from Forest, Mississippi, the family whose children have some serious illnesses?
Yes, Raleigh. Mrs. 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 and Mr. Miguel Flores. They've been in the U.S. since 1999, and they have four U.S. children, 19, 12, 11, and 7. The 11 years old has been suffering for cancer for the past 4 years, and it's been really tough in this family because they not only suffering from the illness of her son, but they also suffering for the pressure to be immigrant and to be illegal and to be afraid to not qualify for public benefits due to these public charges. When Mrs. Nico talked to me, she was asking desperate assistance, legal advice, what she could do. They were afraid that in her way back from Forest to Jackson to the hospital, they might be detained or arrested, either her and her husband and her kids. They're going to be with the protection for each other. So it's being really said that they not asking for any help other than the Medicaid assistance because they're afraid. They're very afraid that it's going to affect them and maybe change the immigration status in the future, or they can also end in deportation. So what they really do is just suffering and pace day by day, hoping for the best. And that is the situation with them.
Well, this is such a terrible tragedy, this public charge rule. It's forcing parents to either stay together and go hungry or access benefits these children as US citizens would be entitled to, but separate. So it's a cruel, inhumane dilemma. Thank you so very much, Nancy and Amelia, for helping us understand that a little better. Now, the public charge issue is one of many ways in which the immigration system seems to erode guarantees of health and social justice for Mississippi families. And another way in which this happens is through the practice by local police of detaining persons on behalf of ICE. Max Myers, our staff attorney, is familiar with this. And Max, a lot of people aren't familiar with the concept of ICE holds. How do they work and how do they affect people?
Yeah, absolutely. Hi, everyone. So I think the best way to talk about this is to talk about a client of mine. I'm going to use a name, a different name for him to protect his identity. But Alberto was home from work in late February, and he encountered a checkpoint, which is pretty common here. It's a way for police to check people's driver's licenses, and he was arrested because he did not have a driver's license. Mississippi is one of several states that does not issue driver's licenses to undocumented immigrants. And in being arrested, he was detained in the county jail. He had a wife and 2 sons. Between him and his wife, they had 5 jobs to support their family and to pay rent on the small trailer that they lived in. His wife reached into their savings to pay his no license ticket, and upon doing so, she was told that ICE had issued a hold, and Alberto was not actually free to leave.
So, Max, how is it that deputies can hold a person for ICE after they've met all of their obligations in the local law enforcement system and solve their outstanding legal matters?
So the sheriff's departments and local law enforcement agencies often work in coordination with ICE to scan names of persons that they believe to be immigrants and who they determine that may be having an unauthorized immigration status. If someone is flagged for that, ICE will actually issue a hold for them and for up to 48 hours. That's the maximum that the local law enforcement agency can hold. Doesn't require a judge. It's actually just the discretion of an agent. So unlike most arrest warrants, it does not go through all of the necessary procedures, presenting evidence, things of that sort. So after the 48 hours passed with Alberto's case specifically, he was still not free. So I actually went to the jail to speak with one of the deputies, and he explained that Alberto was actually no longer held under an ICE hold, but instead ICE had driven to this county jail, taken Alberto into custody, charged him with
I think Max may have frozen up there momentarily. I think what happened is that they charged him and basically were again able to hold him indefinitely. And when Max pressed local law enforcement on this, the deputy told him, look, we can just take him out for a ride and bring him back if we want to and keep this indefinite detention going. So it's a real awful situation that Max is describing. Alberto ended up remaining in county jail, awaiting federal criminal prosecution for a month before the U.S. Attorney's Office finally dropped the charges and transferred him to immigration detention in Louisiana. And he was in detention for over 5 months before our team won bond on his case and were able to return him to his home with his family. So, Max, have we got you back yet? Amelia, while Max's connection clears up, can I ask you to talk with me a little bit about how common is the phenomenon of ICE holds? Are you able to pick up that story and talk with us a little, please?
Absolutely. So ICE holds are not new. They've been going on for years. However, their usage has increased greatly during the Trump years, and we have seen it kind of in our own work. The current administration really prioritizes these actions, this detention policy of picking people up from local jails. 2017, for example, saw a 65% increase in ICE detainer requests. 2018 had a 24% increase, and that was 177,147 people. In a state like Mississippi, that it's a small state and it doesn't issue driver's license to undocumented immigrants, a small step like driving without a license often leads to years of incarceration and eventual deportation. So it could be a very extreme result for the sole act of not having a driver's license, and you can't get one. And it's important also to remember that ICE detainer requests are voluntary. The federal government incentivizes cooperation with local law enforcement agencies, however, through programs that provide funding to agencies that target, and this is funding through programs that target border security and terrorism, but they ultimately result in enhanced immigration policing at the local level, which includes picking up people who just don't have a driver's license. And all of this, as you might imagine, and as the story that Max told indicates, this results in colossal pain for Mississippi's families. It separates children from parents. It separates entire households and communities. And it requires loved ones to take on mountains of debt for legal fees. And it leaves households and communities permanently scarred with empty seats at the dinner table.
So as we've been talking through some of these cases, one thing that's come through is that it affects family. And Max, are you able to join us back and talk a little bit about Mississippi's Dreamers?
I believe so, yes. I apologize about that. It's my back to normal?
Yes, please go ahead. We're talking about Mississippi Dreamers.
Yes, so I think, this is, ICE holds affect all of Mississippi's population. And this is an opportunity to specifically talk about Mississippi's Dreamers. Those are young folks that were brought as children in the United States without authorization. And they're under constant threat of deportation for things that might be what any other 16 or 17-year-old might have considered an immature lapse in judgment. For these folks, it can actually be complete separation and removal from their family and being sent to another country. One of these stories takes place in North Mississippi. It has a little bit of a different ending, which is always nice to hear. I'm going to ruin the ending and tell you that it's going to be a happier ending in this situation. But a group of young boys were out shooting a gun. Young kids. It was an abandoned house. Police officers interacted with them and ended up arresting them. Released several of the boys, but held on to one of them because he had been flagged as someone that did not have immigration status. ICE asked them to hold this young man for his the 48 hours per the ICE hold. And so his mom, in a panic, because not knowing how to get her son out while the other boys were coming home, she organized her community. She reached out to MCJ. We got in touch with people at the jail, the city attorney. The mother had her employer contact us, who also really lobbied the sheriff's department. We were able to share one really crucial piece of information with the sheriff's department, which is that these ICE holds, they're completely voluntary. The sheriff's department does not need to follow through on them. And that's exactly what happened here. They released the boy on bond for his criminal charge, and he is home with his parents and awaiting his criminal issue. Am I still good in terms? I'm always nervous that I'm frozen. Okay, great. I will say that this really, also highlights the importance of an information campaign, which is one thing that we're really focused on at MCJ is coordinating a way for the sheriffs to be persuaded to essentially deny ICE holds and for people to pay their criminal bonds to get them home.
So can you talk about what's going to happen with someone like Daniel, who's out on bond and has an ongoing legal case? Does this give them any kind of reprieve from ICE detention?
So on a very basic level, a bond, it functions as a way to mitigate the risk of a person from fleeing or being a threat to public safety during their time when their case winds through court. Daniel is someone, or not Daniel. The young boy is someone who was one of 400. His family was his family was not, but there are about 400 people out of the 680 that were captured in the August 7th ICE raids that were released under bonds. They are not criminal bonds like the young boy in North Pontotoc, but immigration bonds or released on orders of supervision. And life's not safe and tranquil for them. They might have a case that spans 2 years, and during that time, they're under constant ICE supervision. There was one woman in central Mississippi who was also apprehended in the ICE raids. ICE agents that day in August of 2019 determined that she had a viable claim to asylum, and they released her the next day to live with her family and to care for her young child while she waited her case. In the interim, she had regular check-ins with ICE. She presented at the Pearl ICE office for interviews with her supervising agent. She and her husband were planning their future together. In early of this year, they learned that they were expecting a new addition to their family. And then in February, she was involved in a car accident in which she was injured. She went home to her family, who insisted that she receive medical treatment, and so that she does not either her or the baby that they were expecting. She was fearful because she didn't have a driver's license, which is one factor that you'll see kind of winds around the entire all of these stories really have some element of that, or other charges that are just disqualifying things that set people up to have interactions with ICE in a state like Mississippi here. But ultimately, this person did not report the accident to police. And when the sheriff's department found out about this, they alerted ICE, who then issued a hold on her. And she actually spent time in a young pregnant woman spent time in detention because essentially because she was just targeted for being an undocumented immigrant here. There are other examples of this too, where the ICE hold can function as almost a corrupt bargaining chip to obtain lopsided plea agreements. There was one instance in central Mississippi where police knocked. It was an evening time in July, and police knocked on the door of a household responding. They were responding to a noise complaint from neighbors. They came upon a very large argument, loud, and the officers not speaking Spanish and the couple not speaking English were not able to communicate. And officers, assuming that there had been a physical dispute, despite his wife pleading with the officers that there had not been an argument that had turned physical, it had purely been words, the officers still arrested the man, held him in the county jail for 26 days. And during that period, this is in July, middle of the pandemic, here in Mississippi, that was when the mask orders became mandatory. There were outbreaks. Jails were some of the places that were hit hardest. And after 26 days of being held in jail, during which time his wife tried to pay the bond for him, for the criminal bond, but was told by the officers it would make no sense to pay this. He's simply, as soon as you pay this bond, he's going to be sent into ICE custody because there's this 48-hour hold on him. And so after 26 days in jail without a trial and facing this pandemic, David pleaded guilty. Again, sorry, I should specify fake names. David pleaded guilty to domestic violence to expedite his transfer to the ICE detention center, where he hoped that a judge would eventually grant him a bond that his wife could pay. He had been in Gina, Louisiana for 2 months so far, and it's a total of 3 months of incarceration. And he just recently, we had his bond hearing, which was actually postponed specifically because the immigration judge needed to take into consideration the effect of this domestic violence conviction in terms of determining his threat to society and indicating potentially bad moral character.
So this is another instance, isn't it, Max, where the immigration law system sets up a catch-22 for those caught up in the system. Just like with public charge, there's no good choice. There was no good choice for this individual named David. He had to either endure further detention awaiting a ruling on his improper domestic violence charge, or else he had to plead guilty to a charge he didn't commit. And then that gets held against him in the immigration proceedings. Would that be fair? Exactly.
It's a situation where little things add up to that for any other person, any of our neighbors here in Mississippi, not having your driver's license one day, or having interaction, being a mistaken identity, you're not at risk of actually losing your entire life and livelihood here and being taken to a place where you haven't been, in this particular case, for over 20 years.
So to wrap things up a little bit, our immigration law team does an enormous amount of work at the trial court and appellate court level and tries to troubleshoot problems before they snowball. But another way that we're trying to work on this is systematically with the local law enforcement agencies like the sheriff in North Mississippi to curb unjust ICE coordination and stand up against abuses of power alongside our clients who encounter a lower level of justice in America's legal system, or these catch-22s where there's no choice between losing and losing. So we'll continue to work to enforce the 48-hour rule with respect to ICE detainers, and where possible, provide information to sheriffs and chiefs on their right to decline ICE requests, something which many of them don't know they have the right to do. And our team will litigate and utilize public records requests to learn more about the depth of collaboration and resource sharing between federal and local officials. And finally, we will, as we've described, stand with individuals as attorneys challenging these practices and fight alongside them to generate broad change in Mississippi's over-policing of our immigrant communities. So with that, I want to thank Amelia McGowan, Max Myers, Nancy Sanchez Vasquez, and open up the floor to any questions from our audience. And if there aren't any that are readily queued up, I'll be glad to toss you one to get us started. So it appears that we don't have any questions immediately queued up. So let me just toss one out to you. And this is really a little bit to all three of you, since you all talk to people involved in the system. What is the reaction of the community affected by the immigration raids to the fact that no corporate heads have been prosecuted for their role in this immigration workplace roundup?
So Riley, I actually have an anecdote from a legal clinic shortly after the raids. You know, as with many other organizations, MCJ was part of a coalition to provide a rapid legal response to the ICE raids. We went into communities, met with people in communities, asked them, you know, what was happening, asked them kind of information about their cases, made sure they had food, you know, access to what they needed to survive. And I remember, you know, clear as day, a woman sat across from me one day. It was one evening in one of the communities. And she said, I have worked for this company for 15 years. She said, I have given everything I've had to this company. I've never gotten a raise. You know, but I've given my all to this company. And she said, now I'm here, I'm in tears, talking to you about my husband who is working with me. He is in jail and they're at home eating with their families. You know, I think that, you know, that was the impression that I got, that people are very hurt by this. Obviously, I can't, you know, speak for multiple people, but just, you know, that woman's account, I think, was really, really powerful.
I actually have so that really reminds me of another story that very similar to that. I went to visit a family in October after the raids. It was right after it was an older lady and her husband had been already, he was someone who was fast track deported. He was removed. And when I went to use her restroom, I noticed that she had hanging on her hallway wall a plaque from one of the poultry factories for I think it was 20 years of good service or good conduct or something like that, employee of that. And that just really, I mean, I just, that really floored me to see that as well. I mean, it's people who have long-term, you know, relationships where, you know, they were with these companies, they were employees for many, many years, active in unions in some situations, and to have them, you know, completely turned out like that and refilled with positions quickly after was pretty wild.
Thank you. Any stories you've heard, Nancy, in your outreach?
Yes, Riley. I remember Miss Alicia from Canton. She is an old lady. She is maybe in her 60s, Max, or so. And she has been working there for more than 30 years as well. And now she is being detained, and she is have this order remover, and she's elderly people already, and not have nothing on her place where she's coming from. And here, the only thing that she was having is her job and a little home, and now is in risk as well. So it is really devastated to see those families, how they've been struggling.
There's one more thing I want to ask the three of y'all, if you've heard from the folks we help to serve. And that is concerning this report that came out 2 days ago that indicated that at the very highest levels of our Department of Justice, there was a explicit effort to take children away from their parents. And I know folks in this crisis that they're dealing with their immediate needs, their children's health, their children's need for food, their own need for shelter. But when they hear news like that, how do they react? That the United States federal government is saying we need to take children away from their parents at the border.
It is really panic, especially here in Mississippi, where the community is small. The families getting on panic, and they first act is not wanted sending the kids to the school because they are afraid that they're going to wait in there for at the schools from them. They stop going to churches. They stop going to the stores. They practically trying to hide from when they come this kind of news. So they heard this happening around the community is where the panic start. And like I say, they suffer the kids as well for the afraid of the parents.
Max or Amelia, anything to add there?
I think also this, sort of highlights what we also discussed with the public charge rule, that the impact, of the separations, the policy is at the border. However, there's a much broader chilling effect, right? Just like public charge, it doesn't directly affect, all people applying for green cards, but the chilling effect is much broader. So people are fearful of how this action, can sort of ripple out and start affecting a lot more people. And I think that's also the intended purpose of both separation of families at the border and the public charge rule, not only to impact, people that are directly impacted, but also to create this chilling effect, that's much broader.
Yeah, I would say, I mean, it's a form of the way that people described it. It's living in a state of terror, basically. You have again, I mean, if you think about it, I think the raids is, I mean, it's an extreme example, but just putting yourself in the shoes of someone who was arrested in the raids and from their family, you have people who went out. I mean, a completely normal day started out. They went out to work, took their kids to go to school, and then completely upended. We had someone who was just released after over a year of detention, and he actually came home in the exact same clothes from the raids. I mean, covered in poultry blood, muddy boots, and that I mean, that should show you. I mean, that was how people left that day. They didn't have time to prepare for this. This was dropped on them, and that is one of many ways in which that, coupled with the threat of ICE holds, any little misstep leading to this looming, giant looking over your shoulder, ready to deport you. That is a very terror-filled day on a daily basis.
Well, when this raid broke out, I remember on CNN there was a heartrending segment where some 9 or 10-year-old child was saying to somebody, "Please, just can I see my mother?" And the mother had been picked up in these raids. We've got to do all we can to remedy this, and with your help, we can make some further progress. But it is a long, hard fight, and it requires a year upon year commitment. It's not something that's going to get wrapped up in 12 months. So with that, we'll close out this portion of the discussion, and we'll thank you for taking part in it, hearing these stories, and keeping your interest in this important issue. And we'll turn it back to our president, Vangela Wade. Thank you.
Thank you, Riley, Amelia, Max, and Nancy. Thank you so much, especially for broadening our understanding, mine. Every time I hear the challenges that these families are facing, whether it's families who are immigrants, who are part of the unprecedented raid from 2019, and or the people that we're working with who are seeking asylum. When I hear their stories, when I hear the struggles that they're having within their family and the terror that they are often living in, I am just, one, appalled that we hear that in the United States, definitely in Mississippi, but it is something that it reinforces the fight that we have every day at MCJ to stand in the gap for people who are often voiceless and who are taken advantage of and not given full effect of our laws. So I am just thankful that you all are here to our audience today, that you're hearing this information, that you're receiving the same briefing, the education that I receive about these issues. And now that you know, please help MCJ change the playing field for our immigrants, for our undocumented workers who've been here for years, who've worked in our communities, who've paid taxes on the earnings that they've made, who attended our churches, attended schools. Let's stand in the gap. And you can do that by joining MCJ and helping us, partnering with us to provide the legal representation and the advocacy that our fellow neighbors need and should have. I also want to thank you again for watching and participating in today's conversation. And I want to remind you that on October 22nd, 4:30 p.m. Central Standard Time, you are invited to join us for our 2020 Champions of Justice Great Mississippi Road Trip. So if you want to know more about that virtual program, please go to mscenterforjustice.org/champions to find out how you can join us for that great event. So again, I want to thank you. Please be safe, be well. Until next time, have a great weekend.